2022B, the case state versus Julius Malema and Adriaan Snyman. The date is the 18th of June 2024. Presiding officer Mrs. T. Clear, public prosecutor Advocate J. Caesar, defense Advocate L. Julius, SC for accused number 1, Advocate Matthews, SC for accused number 2, interpreter is Ms. Murray, clerk is Ms. Ashim. This matter has been set down today for further evidence. The state have already closed its case in this matter. The matter is on the road today for the defense's case. Just before we get to that, I'm not sure whether they actually asked the 3 video clips be handed in as exhibits as well, and marked as exhibits.
Were they not admitted as exhibits?
I'm not 100%
I don't think it was passed over to me, but maybe I'll need your assistance as well, Advocate Ouders, Advocate Matthews. I cannot recall whether it was formally admitted but just not handed to me. Or can we revisit that aspect at a later stage to save time? It's up to Advocate Ouders.
Please the court. Your Worship, I confirm that I act on behalf of accused number 1, instructed by Ian David's attorneys. Your Worship, I also confirm that there had been a discharge application in terms of section 107 of the Criminal Procedure Act that did not succeed. We will now hear from the defense case. Your Worship, I further cannot review that the videos were accepted as exhibits. Part of the heads of argument have been referred to extensively. There was an argument that they shouldn't be played, they've been played. I think they were real evidence before the Honourable Court. So I think that was assaulted. I also believe, Your Worship, based on the global decision that had to have been clarified before we even got to 174 because we knew what evidence we faced. So I'm firmly of the view, Your Worship, that they are before this Honourable Court. I'll check my list of exhibits in due course, Your Worship.
Yes, I'll also do that.
Your Worship, when it now turns to the defence case, Your Worship, we as the defence have sat together and agreed that the accused number 2 will present his case first. And we're in agreement on this course of action as defence counsel and as they say, reversing the order as per the charge sheet which is permissible by law on the basis of the state proceeding capital decision. So accused number 2 will proceed to present his evidence first as the court pleases.
Thank you. I just want to know. Advocate Matthews.
Good morning, Your Worship.
Good morning.
Your Worship, I confirm with my learned colleague for accused number 1 as stated, not only regarding the sequence in which we will give evidence, but also regarding the video.
Thank you.
I'm ready to proceed with the defense case for accused number 2. And in doing so, I call my first witness, Mr. Martin Wood.
So, you'll be calling defense witnesses ahead of your clients, if you decide to call your client. The value thereof still to be determined.
Yes. It is probably likely that I will not call Mr. Snyman.
Your prerogative. I'm just wanting us to be on the same.
You're entitled to do that, Your Worship. At this stage, I have no intention of calling Mr. Snyman to testify. I'll call Mr. Wood.
If at any stage you change your intention, you may
Then
feel
I'll
free
have
to
to-
do so, but just
I'll have to bring an
keep in mind
application then and place on record why.
the sequence of
Yeah.
defense witnesses changed. Not a problem. Advocate Caesar, I'm sure you do not have any problem with the sequence of events. I myself do not. It is totally permissible in law. Thank you.
The witness has no objection to the video, live video recording of evidence.
There's also a request from the EFF to have a sound, a live stream, a live link. Because you also could ask for clarification technology. That's the only one that I'm aware of.
Yes, before Q1 and 2 entered, I raised the issue with seeing all the candidates, sorry for the witness, we need to get clarity on this aspect. There was an application received from SABC News. Others are not known to me, so I cannot acknowledge any. I see microphones from EFF, I see, don't know what this is. Got no idea on Newsroom Africa, but there's no application. So if I can please, I ask them to write the stations down so I can acknowledge the presence of whoever wants live recordings and see if there are any problems with it. Happy with that arrangement?
I'm happy.
All right, well then, in that instance, oh, apparently the form is on its way.
Can I just approach who's number 2?
The station and let's see if I can do it. Ronald Masinga? Ian, I'll just do it. May I then just read out? I don't see that any names for the EFF if you want to just endorse so I can read out and acknowledge the presence of all of them.
You should now approach my phone.
Certainly.
Excuse me.
Thank you.
The department request your worship to allow the EFF to do a live streaming, worship, only of as per the order that the officers worship and the microphones have already been set up. The live stream.
Which, the live stream will be done by me.
They've got their own media.
Yes, but who will be the person doing the live streaming?
May I inquire?
Yeah, it's just everyone
Ah,
is given a name, so I just want to place.
Please excuse me, Worship.
No problem.
Thanks, Your Worship. If I sit, I think I might disappear below the...
Worship, I have the spelling of the name. It's S-I-X-O. I-X-O, the first name. And her surname is G-C-R-L-R-S-H-E. It's at the EFF live streaming. Thank you.
Oh, thank you. Does anyone have any objection? I'll first read out the media houses, including the names. Then just hear if anyone has any problem with the media present. Firstly, there's Ronald Masinda on behalf of ENCA. Sipa Balwar with Mkana. Mdena, I can't say Mdena. Also from ENCA, there's Sipo Malema, New Zealand, Africa. Sia Bonga and Kariana, New Zealand, Africa. Yampelo, Msinyo. Mpumakapa TV. Do I acknowledge them? Yuduma Deniso, also Mpumakapa. Then is Sitandiwe Elaku, News 24. There was an application, formal application by SABC. But the person I've been given the answers plus 2 others were listed. And then the last thing was the EFF, which will be dealt with by SECO and Risha.
As worship,
Everyone concerned accept that?
We accept.
we do worship.
Thank you. I remind you people and you've gone over the rules that you and the adults. Please abide by it and so we can proceed. Thank you. So you're calling the witness?
I'm calling the witness.
Your full names, please?
Martin John Hood.
Good.
Hood, H, Your Worship.
Good.
Hood.
Do you have any objection in taking a prescribed vote?
No.
Do you then swear that the evidence you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
Mr. Wood, since you will need interpretation in the matter, up to 5 English,
Not for my client, worship.
Advocate Matthew.
We can proceed to us for that interpretation. I don't know whether there are people in the crowd who might like one to hear. But
What hour is it?
not for the accused, we don't require.
Mr. Wood, please keep in mind that I'm writing down your evidence. So after the sentence, I'll just pause for a second or so, so that you can with what you are testifying about.
Yes, Your Worship.
Thank you.
Thank you, Your Worship. Mr. Is it correct that you are an expert in the Firearms Control Act 60 of 2000 as amended?
I was admitted as an attorney in 1990. I practiced continuously since then. In 1997, I was invited by the South African Police Services to be part of the consultative process for the drafting of what became the Firearms Control Act on behalf of the South African Gun Owners Association, of which I was also the vice chairperson at the time. from 1997 until when the Act was passed in Parliament in 2000. I was part of the process of consultation where the Act went through numerous drafts, and I made a presentation both personally and on behalf of the South African Gun Owners Association to Parliament in 2000. Concerning the structure and the content of the Act. From 2000 to 2004, I was part of the civilian component that helped draft the regulations to support the Act. Where I worked closely with the South African Police Services, legal services. From when the Act was promulgated in July of 2004, I've been involved in numerous processes concerning the Act. Most recently in May of 2023, my apologies, Your Worship. Numerous processes, both judicial and parliamentary. The most recent of which was that I made a presentation to Parliament in May of last year to the Portfolio Committee on Police on behalf of the South African Arms and Ammunition Dealers Association, where the Minister, Deputy Minister, National Commissioner and various other senior police officers were present. I did that at the request of the chairperson of the Portfolio Committee. I was also a panelist Firearm Summit held in 2015 in Parliament by the Portfolio Committee on Police.
Correct to say that you represent the security industry?
Yes.
We are concerned in this particular matter with tactical security services situated in the Ballistic. Are you aware of this company?
I am.
Have you had dealings with this company?
Part of my practice involves the obtaining of firearm licenses for security service providers, and in that capacity I have made applications, prepared applications on behalf of tactical security services.
Did you say that you are, sorry,
What notes are you need the uniform? Just a second,
sorry.
I have prepared, what is it?
Firearm license applications.
On behalf of capital.
Correct.
If you could just, in broad outline before we deal with the specific matter, explain to the court how a security company would go about obtaining firearms for their security guards and the procedures that are used. If it is that simple.
Once a company is registered with the Private Security Industry Regulatory Authority, SIRA, it is automatically accredited to own firearms. That company must nominate to the police a person who is responsible for making the applications for the firearm license applications.
If we could just hold there. I have a document which unfortunately I sent off to get photocopy. But we can simply refer to the evidence of a Mr. Stander who has testified for the state from SIRA, as indicated in his testimony, as well as the evidence of Lieutenant Colonel Janssen, that the person appointed or the responsible person for tactical security services was Mr. Clement Ndluli.
I checked my records personally, and Mr. Ndluli was the responsible person according to the documentation that I prepared in 2018, and he was also the member of the closed corporation in 2018.
Tactical security services was a closed corporation.
Correct.
We use it loosely as saying it was a company, but that's not 100% correct.
Yes.
Mr. Ndluli, Clement Ndluli, he was the majority holder, if we call it that, of the closed corporation.
I don't know what his membership was, but he signed the application in his capacity as the member.
Okay. Now, let's follow the procedure that would now happen. You say that once a company like this or a closed corporation is registered with SIRA, it automatically becomes entitled to acquire firearms.
The word is accredited, yes.
Accredited. We have heard the evidence of Mr. Stander that tactical security was in fact accredited. And I'm sure you picked that up during your application for firearms on MER.
They had to be because they were granted firearm licenses. Their licenses were approved. So they had to be compliant with that accreditation.
We've also had the evidence of Lieutenant Colonel Janssen about an inspection done at tactical security. about the books that were kept and all the registers that are required to be kept by a company, or let's keep using the word company, like that. You are aware of that?
I'm not aware of the specific inspection, but police regularly inspect the books.
Now, I am the new security guard, and tactical security now wants to arm me because I'm going to be guarding an ATM. I want you to tell us the steps that need to be taken and the permissions, etc., and who is responsible for the firearm that I'm eventually got now in my possession.
The individual security officer has to be registered with SIRA, the regulator. They must have a competency certificate to possess a firearm.
Yes.
They must have completed additional training known as the business purposes training. In order that a firearm be given to that security officer, he must be in the employ or service of the license holder. The responsible person or someone delegated by the responsible person signs the firearm over to the security officer by way of an entry, a written entry, into a daily working firearm register. The security officer co-signs that they received a firearm, and then the security officer is issued a permit by the responsible person or someone delegated by the responsible person, which is a temporary license in effect, to possess that firearm on the conditions, according to the conditions stated on the permit.
I'll show you a document dated the 13th of March 2018 from the South African Police.
I note it.
March 2018, but was there a date?
It's dated 13/3/2018. I will, unfortunately, I've asked for it back because we were on our way to make copies of it.
You wanted it on the copy?
I will read it into the record. I think that's the easiest.
So I can write as fast as you do.
No, doesn't matter. I can add it up.
No, just on the
I'll read the first few lines because that's what is of relevance there. It says the responsible, this is a warrant officer, A.M. Small from Brighton Beach, designated firearms officer. I will also show my learned friend the document. It says the responsible person for the safe handling and proper handling of firearms is Mr. T.C. Mzuli with ID number 760321 5498084. Who is in possession of a relevant and valid competency certificate to handle and use all categories of firearms in possession of the above security company. You read this?
I have.
Does this coincides with the evidence or corroborates the evidence of Lieutenant Colonel Janssen, who was the responsible person for firearm compliance and tactical security? No.
If I may just put that slightly differently, Your Worship. If that were not correct, tactical security would not have been granted the firearm licenses in 2018.
Why we are going through this exercise is because of the provisions of section 120.10a of the Firearms Control Act, which is count 6 in this matter. And this section, the charge against accused number 2, and I'll read it to you. It says that on about the 28th of July 2018, at or near the Sisa Dukashe Stadium in Mdantsane, the accused had unlawfully supplied or in any other manner give possession of a firearm and or ammunition to wit a .223 Norinco rifle and or a firearm the make of unknown to the state and a .223 Remington bullet to Julius Malema, accused number 1. Now, what is important here is this section. Did unlawfully supply or in any other manner give possession of a firearm. Now, if I could just, before you reply to this, tell you that in a request for further particulars, the state was asked in what manner it alleged that the accused handed a firearm to Julius Malema. And the answer was, I will read it to you. Sorry, I need to find the right place. Okay, got it. The state's reply was, the cartridge found on the site after the event of the 28th of July 2018 was fired from the rifle serial number SPA 249. The state alleges that the rifle was handed to Mr. Malema by accused number 2. You understand? That is what the further particulars say. When I last looked at the law, the state is bound by that answer. But in any event, I want you to comment on the provisions of section 120 of the Firearms Control Act of if there is no evidence that he physically handed the firearm to you, this phrase in any other manner gives possession of the firearm.
So,
And how far back are we going? Are we going back to the manufacturer and marine code?
Your Worship, first of all, I think it's subsection 10, bracket small a.
Yes.
Yes. Firstly, there is no definition in the Act of supply or possess. I've just checked that as you were asking the question. To give an absurd example, if I may, and speaking from experience, if one had to take a large security company that has many thousands of firearms, and there are quite a number of such security companies, to use this section, well, I have never seen this section used in my experience over 20 years to charge the owner or even the responsible person with such an offense. What almost invariably in my experience would happen is that the point of contact between the police and the license holder would be the responsible person. One of the primary functions of the responsible person is the keeping of up-to-date and accurate records. Excuse me. And there are registers specified in the regulations and how they are to be maintained. The police would then inspect those records and go through the chain of possession or use that those records specify. And they would then go to the person whomsoever those records specify as the last person who used or possessed that firearm. And then it is that person that is either asked to provide a statement or is charged with an alleged offense. And if I can just take it one step further, I've acted for many large security companies, and I cannot recall where the owner, the owner or director has been charged with this type of offense.
Let's use an absurd example. Fidelity, probably got hundreds, thousands of guards. Who knows how many firearms? Any one of those guards does something wrong, the owner will be charged because he, in some or other manner, gave possession of the firearm to the guard.
Well, that's the absurdity that I'm referring to.
And anyway, the Firearms Control Act makes provision, does it not, for a person who has a license for the firearm to hand it to somebody who doesn't have that.
Yes, there's a number of reasons for that. I think it's section 22 Section 22 of the Act. And, Your Worship, to give a simple example, if I may, the Act provides for this simply because for a person to obtain a competency certificate, they are obligated to handle and discharge a firearm. So you can't use and possess a firearm without a competency certificate. But in order, for example, to be trained, the training provider allows you to use their firearm under their supervision and control. That's the requirement of the Act. And there are many other examples where that would happen. For example, on a shooting range where someone wants to test fire a firearm, that is specifically provided for in the Act. It's called demonstration and display. Where someone wants to engage in a sports shooting competition, for example, many shooting associations provide firearms for that purpose, and they're used under the supervision and control of an official from that body. And a simple example, which is a fairly common example as well, is if someone wants to go hunting, they use somebody else's rifle in their presence and control when they go hunting. It's very common.
Now, we apply what you regard as your testimony to this particular matter. And I must add from the outset that we will be comprehensive to ballistic evidence to show that the firearm in question did not fire the cartridge shell. So what I'm now putting to you is based on the premise that the state's evidence led so far is correct. You understand?
I do.
This particular firearm, according to all the records, was under and Lieutenant Colonel Jansen, who did a inspection, was in the possession of a person I'll call him Mr. L.M., a security guard employed by technical security company. So, you understand that?
I do. It was signed out to him, in other words.
It was signed out to him. Mr. Ndudi was the responsible person at the time. That is not only that document I showed you, but also the evidence of Lieutenant Colonel Jansen. Now, who would be the responsible person for this particular firearm?
Your Worship, we need to draw a distinction between responsible person as contemplated by the Act, which is a specific individual, and who is responsible for the firearm, which is different.
Okay.
So the person who is responsible for the firearm would be the person to whom it was signed out from the daily working register and who had the temporary authorization to possess that company firearm. That is the person that the police ordinarily, and in my experience almost invariably, would hold accountable for any misuse of that specific firearm. And I would like to add as well, bearing in mind that I was involved in the genesis of the Act, that was always one of the principal purposes of what became Regulation 21 of the Firearms Control Act, which is intended to enable the police or a regulator to ascertain who had possession and use of a particular firearm at a particular time.
You said there were two scenarios.
Well, the responsible person being the one in the police records, and then the person who is responsible. I'm speaking about the person who is responsible, not the responsible person.
Do you think under these circumstances, if I may ask you this, if you don't want to answer them, say Mr. LM did something with a firearm, fired a shot at his girlfriend in anger. Do you think Mr. Julius would be held responsible in law for that?
I think I've answered that. I've said that the starting point for an investigation would be to go to the responsible person. But then that the records that are required to be kept in terms of Regulation 21 and Regulation 22 show the chain of possession and custody, and ultimately the individual security officer would be held accountable.
Is that the purpose of these regulations?
Absolutely. And I want to emphasize that, again, in my experience, where I have conducted many criminal trials, I've represented accused based upon an offence committed with a business firearm. It is the security officer who had possession that is charged. The only time a responsible person might be charged would be if there is improper record keeping in some way, and then that is covered by Section 122, I think it is, which deals with administrative fines. So in other words, it's an administrative issue, not a criminal issue.
You have read the ruling in terms of the Section 174 application before this court, is that correct?
I have.
Of course, worship is only entitled to use a discretionary matter to use the 174 so desire. But I want you to comment on this ruling by the court in terms of what Section 174, if you are able to. If you don't want to, just tell me.
Would you like to read me the part, please?
I'll read it to you. It says it comes, I'm reading from page 26 of your worship's ruling, from line 17. It says it comes down to the fact that count 4 and count 6 remain a statutory offence. It was confirmed in the evidence so far presented by the state that the firearm in question, being SPA 249/14, is indeed your firearm or the company's firearm, then inaudible, I should put it in that manner. The cartridge that was picked up at the scene or close to the stage or after the incident is linked with microscopic ballistic analysis to SPA 249/14. Much emphasis was placed on the fact that none of the videos or witnesses testified that they saw you, speaking about you now, handing a firearm to Mr. Malema, but that is not the charge. The charge is, and I will read it for clarity, it is much wider. It is unlawful supply or in any other manner give possession of a firearm or ammunition. being the Narinka firearm and a Remington bullet to accused number one, so the actual not seeing or handing over is not a requirement in terms of section count 6. It is supply or in other manner to possession.
With respect, Your Worship, first of all, the firearm could never have belonged to an individual for two reasons. The first is that the license holder is Tactical Security Services. And that is a separate legal entity to any other corporate or individual person. Secondly, it goes back again, and Your Worship, I say this with respect, to the absurdity of the interpretation of the Act, because it seems so literal and so strict that you could say that the manufacturer could be held liable for making and supplying the firearm to a wholesaler who sold it to a retailer who sold it to a company or an individual. That is not the purpose, in my opinion, or the intent of the legislation. And I've never seen such a charge. I said earlier, I've never seen such a charge other than in circumstances where there was some form of direct interaction between the parties.
If I may move on to what is termed a blank gun. Sorry, you would mind just confirm with us. Is it, I'll ask you this, is it correct that you were shown we were probably having difficulty with bringing this into the court premise? We'll see if we can, we had that agreement that the worship will recall that if we wanted to bring any firearm in, we would notify everybody before the time. You were shown a firearm, is it correct? What's this? Called a blank gun.
I've seen many blank guns. I haven't been shown specifically one for this matter.
Oh, sorry, I thought they'd shown.
No, I haven't.
I think I'm correct. These blank guns, are they required to be licensed?
I'm going to say a very simple no, Your Worship, because they are sold without licenses, and the National Prosecuting Authority and the police accept that such sale and possession is lawful.
You are aware of a document from the National Director of Public Prosecution, I think Advocate
The cock.
de Kock is the author thereof, in which he notifies the police that no prosecutions must take place for these firearms.
That's correct. I'm aware of it. If I can just add as well that it follows that the possession of the ammunition used in those blank guns is lawful as well.
Well, we have a ballistic expert that's going to testify about this particular gun. I would have liked to have shown it to you, right? But we will leave it at that. If it becomes necessary during the cross-examination or the re-examination, I will ensure that I get permission to bring it in here, because it's going to be obvious to everybody that one cannot distinguish between the real one and blank.
Your Worship, as I indicated, I've seen a number of blank firing objects and their ammunition. And although I'm not a ballistic expert, I own a large number of firearms. I'm an enthusiastic shooter and firearm collector, and I cannot distinguish between a blank firing object and a real firearm. They're in fact designed both in terms of appearance and their mechanical working abilities to be exactly the same as a real licensable firearm.
Thank you, Mr. Butler. Sorry, just one further question. My colleague has pointed out. Were you aware that Mr. Snyman was not a member of Tactical Security Services in 2018?
I've checked my records, and the member was Clement Nduli.
Thank you. Sorry, could I just approach the accused for me? Apologize. Sorry, I was about to apologize for the accused being late. They had in fact gone to a different court. But please want me to apologize on their behalf. Thank you.
Thank you. Accepted audits, cross-examination.
May I first, my sister? She's not there. I have no questions for this witness.
Accepted Sisa, cross-examination.
May
Need
I,
a minute?
yes, Your Worship, may I just request a brief adjournment? One, I want to make a copy of the document that was at the Matthew's disposal for all the parties involved. Number two as well, I just want to also make a copy of the document they referred to about the NPA Advocate de Cox draft. I do have it in my possession. I'll just make copies for everybody.
Thank you.
So the
No
adjournment,
objection.
adjournment will be half an hour, Your Worship?
Half an hour.
Quarter to.
It's up to you. I'm in my office, available, ready.
Yes, Your Worship, what we will do as soon as I'm done, remember, I might struggle to make copies here. As soon as I'm done, I'll call you, Your Worship.
Whatever. please don't call me, ask the police officer to call me.
Okay, and
I
you explain.
know what you mean.
Yes, you do.
The matter will then stand down for that purpose and just call me at any stage when you are. Thank you.
Alright.
Your evidence solely here is to assist the court today in the interpretation of section 120, subsection 10. Is that correct?
No.
What is the purpose of your evidence today?
I've given evidence about the provisions of Regulation 21 and 22 and the practical processes involved in managing business firearms.
You referred to section 120, subsection 10, is that correct?
I beg your pardon?
You were referred to that particular section.
Subsection 10,
That's correct.
small a, yes?
That's correct.
Yes.
Can you read it out loudly?
You want me to read it?
Yes, please.
It is an offence to, and then brackets A, sell, supply, or in any other manner give possession of a firearm or ammunition to a person who is not allowed, in terms of this Act, to possess that firearm or ammunition.
What is your understanding of that particular section as you've just read it to court?
Well, I think first of all that it's a very broad and very section of firearms and ammunition, which has got its own set of regulations in order that you may sell or dispose of a firearm. Supply is another very broad word which is not defined in the Act. And then in any other manner give possession. Possession is also not defined in the Act. So it's a very broad, possibly quite vague provision of the legislation.
As it stands here in its simplest form, what do you understand from it?
What do I understand
Yes.
from it? Sorry, you're going to have to contextualize it because
Yes.
it's got so many different meanings.
Yes, it says that it's an offense to supply or in any manner possession of a firearm or ammunition to a person who is not allowed in terms of this Act to possess that firearm or ammunition.
So there are, by way of example, there are numerous disqualifications contained in the Act that prevent a person from possessing a firearm. So you need to put to me, with respect, an example of what you are talking about, and then I'll gladly comment on it. Like I said, this is so broad that you can't just say, what does it mean? It's applicable to a variety, a large variety of different situations.
To me, it looks pretty simple. I want to put it to you, to me, it looks so very simple. It says that you are not allowed, it is offense, to sell, supply, in any other manner, give possession. In any other manner, give possession. It's very simple. I don't understand what you mean when you say it's very broad.
I don't want to argue with you, but you should read the whole section, because it says, to a person who is not allowed in terms of the Act to possess a firearm. You can't quote a part of the section. You've got to look at the entirety of the section.
Yes, I understand that.
But
It's
that's
still
not
very
what you're
simple
putting
to me.
to.
It's still very simple to me that it's a person who's not allowed to possess this particular firearm shouldn't be possessing that. Is that correct?
A person who's not allowed to possess a firearm shouldn't possess a firearm. Correct.
You said earlier that you were involved in drafting this legislation, so I want to know what was the purpose of putting this particular section into the Act.
I was involved in the process of consultation on the Act. I can't speak as to a specific purpose for a specific section because I did not draft the Act. I was consulted on the Act.
Were you aware of this particular section that is there?
Yes.
And what was your view of this particular section when you saw it there?
I can't remember. It was 27 years ago.
As a matter of fact, as I understand it, that it is indeed an offense to allow a person who is not in possession of a particular license or competency to have a firearm in his possession. Is that correct?
No, you're incorrect.
You explain to me?
Section 22 permits it. Regulation 21 permits it. And there are probably other examples if I had to apply my mind to it. There's also a provision, it's called an SAP 539, which is contained in Regulation 86 for the storage and possession of somebody else's firearm. That's examples that come to hand, immediately come to hand.
You said you've never in your career seen this type of charge in your 20 years. Is that correct?
No, I didn't say that.
What did you say?
I said that in my experience, I've never seen this section applied to the owner or a responsible person of a security company.
But have you ever seen anybody being charged under this particular section?
Not that I can immediately recollect, but that doesn't mean to say that it hasn't happened.
You also made an example earlier that you've never seen this particular section being applied. Then you also said that there must be a direct action, interaction between the parties. I don't know whether I recorded your answer correctly, but can you just explain what did you mean when you say there must be a direct interaction?
I'm not quite sure what part of my evidence you're talking about, so I'm not sure what you're referring to. What I meant was, when you give possession, you can do it in a number of different ways. So you can hand it to somebody, or you can allow them to access it. But possession is not defined in the Act.
If I give you a scenario that, for example, say accused number 1 fired shots in the air with a particular semi-automatic rifle that was provided by accused number 2, would this offense then be, this particular section then be applicable in those instances?
Well, you're not giving me facts, so I can't comment. I don't know what the facts.
That is, he's putting facts to you.
So you're saying that accused number 2 gave accused number 1 a firearm?
That's correct. To fire shots in the air at a particular stadium here in East London.
Okay, but please bear in mind, as I pointed out, this section is not that simple, because it says who is not allowed in terms of this Act to possess a firearm. Mr. Malema, as I understand, accused number 1, is not unfit to possess a firearm. So he's not allowed in terms of this Act. He's not disqualified in terms of the Act from possessing a firearm.
I don't know if I understand your answer properly.
I can give my firearm to you in my presence. That's not an offense, unless you have been declared unfit to possess a firearm.
But can you give your firearm to this particular person knowing that he's about to commit an offense when you are present and he commits an offense?
Now you're asking me to comment on the state of mind of someone. I can't comment on the knowledge of an individual.
Are you allowed to do so, sir? That's the question.
Are you allowed to give possession of a firearm knowing someone's going to commit an offense?
Yes, and in your presence as well.
That may well be a criminal offense.
Yes. Isn't that the reason why this particular section was incorporated, for that exact purpose that you're just referring and confirming that?
I'm sorry, I have to disagree with you, because It doesn't say anything in this particular section knowing that that person's going to commit an offence. What it does say is who is not allowed to possess it. You've got to read the entire section.
Mr. Woods, isn't it just a matter of interpretation? You interpret something, I interpret differently. We're both lawyers reading the exact same thing and understanding it differently. Isn't that what happens in the legal profession?
Yes, I'm here to give an opinion. And then I'm also here to explain to the court what's happened in my experience.
So why do you think that your opinion is the be-all and end-all of this whole case?
I've not said that.
Yes, Papa, no further questions for this witness.
I have no examination.
Unfortunately, I do miss things. Since I have not come across someone with such vast experience, you will forgive me to tap into your knowledge and to educate me.
Thank you, Julius.
Firstly, do you own a blank file? As you refer to a real one and a blank one. Do you own a blank one?
No.
Have you ever fired a shot with someone else's blank gun?
Yes.
And in firing, the similarities between a blank and a real?
Absolutely the same, Your Worship. And if I can just give an example, the Firearms Control Act provides for the use of what's called movie or cinematic props. Television, it's a blank firing firearm.
Now, Mr. Wood, you mentioned two words now, the television and the TV movies. Are those type of blank ammunition available in South Africa readily to buy for any man on the street?
The ammunition or the firearms?
The ammunition.
Yes, it is.
Where?
It's certainly available on the internet. There are internet sales. I have a box of such ammunition. It was given to me. You can buy the firearms, the objects that discharge that ammunition over the counter as well in many, some gun shops even sell
Yes,
it.
no, I don't dispute the fact that you can buy the blank TV gun, TV movie gun, firearm, whichever you want to call it. I'm asking if the ammunition that simulates the real firearm, including muzzle flash, etc., those blanks, are they available for sale?
Your Worship, they are. And can I assist you by... There is a SABC Ballistic directive. I don't have it with me. And it relates to the definition of ammunition in the Act. If you'll just bear with me.
I don't know. Yes, I'll bear with you. You may have asked it, so I listen, but I'm quite aware of what the definition says of the of ammunition in our firearm act?
If I may, Your Worship,
Person?
a cartridge. So the definition of ammunition is a primer or complete cartridge. Cartridge means a complete object consisting of a cartridge, case, primer, propellant and bullet or a projectile.
Yes.
So what SABC Ballistics have said is that anything that doesn't have a projectile is not ammunition, and blank ammunition falls into that category.
Okay. I understand that explanation. I'm asking that the blanks that are for sale, does it have muzzle flash or nozzle flash as is seen on TV sets,
Yes.
TV movies?
Yes,
You are certain of it.
absolutely certain.
Now, I don't have many questions. It's just quick stuff items that I would like clarity on. Nothing more, nothing less. I've marked them, so it won't take me long. I quote, you've clarified in cross-examination and you disagreed with Advocate Sisa, but I quote from what your evidence in chief says, because I've marked it. I've never seen this section used in more than 20 years or discharge to charge a person or an owner with this offense.
Responsible person.
That was not part of the evidence. I'm reading, okay? Nonetheless, so you've never dealt with the section in more than 20 years. You've never testified about the section in 20 years.
No.
So this is the first time ever you are asked to testify about section 130,
Yes.
2010, small a.
Yes.
I see. Now, you also mentioned in cross-examination, Mr. Malema was a licensed firearm holder or a competent person to...
As I understand the situation, he's not unfit
Not
to possess a firearm.
Are you aware of his limitations in that aspect?
I am.
And his?
I do know that he has a competency certificate.
Or up to what caliber firearm?
No, it's not related to caliber, it's related to category.
And if you speak about the firearm issue that is mentioned to be the SP firearm, that is a rifle.
There are 4 categories of competency:
Yes?
handgun,
So
rifle.
then let us be clear. It's been established that under conviction, please address me, Advocate Matthews, or Advocate Holder, sorry, it involves your client, that Mr. Malema may possess up to a 9mm firearm, not a rifle.
That's not correct. It's not, competency is not related to caliber. It's related to the type of firearm.
So if you own or you are competent to possess and own a firearm up to a 9mm firearm,
Well,
you can also have a semi-automatic rifle.
you could have a semi-automatic carbine, which is a semi-automatic rifle. You could, I suppose, in theory, have a 9mm rifle. 9mm is a caliber, not a
I'm
cartridge.
speaking specifics here, not a 9mm rifle. I'm speaking about the SP firearm or rifle, which is an issue in this case, not in general, this case.
Your Worship, if I could perhaps approach it from a slightly different point of view.
Certainly?
I said that Mr. Malema is not unfit to possess a firearm.
Yes.
The reason why I said that is I know that Mr. Malema had a competency certificate.
Yes.
You cannot have a competency certificate. It doesn't matter what that competency certificate is. You cannot have a competency certificate unless you've been, if you are unfit. So if you are declared unfit, then the process means that your competency certificate is cancelled.
I'm not disagreeing with you regarding competence. I'm asking you about possession of a certain type of firearm, being competent or not.
Your Worship, you can possess any firearm. under the direct supervision and control of the license holder. You do not even need a competency certificate.
So in this instance, we all know Mr. Snyman was at the scene.
I don't know that, but
I'm telling you he was at the scene.
yes.
Now, the example about fidelity guards and charging the owner if one of the guards commits an unlawful act, it's ludicrous because it doesn't fit in with the facts of the case that we are dealing with now, today.
Your Worship, if you might recall, I made reference to Regulation 21 and 22.
Yes,
And the purpose of those regulations is to establish a chain of possession.
yes,
And in order, that chain of possession is necessary in order to establish who should be in possession of that firearm
yes.
and who is entitled to use that firearm.
Yes, I don't think that is an issue in dispute in this case. I think we are all in agreement on that part. There was a question asked to you by Advocate Matthews, and I'll quote the question and your answer, if you can just clarify for me. It was asked from you, in this case, who will be the responsible person? You replied there's a distinction between responsible, a responsible act, and who is a responsible person. And the person responsible is a person who it was signed out to and had the temporary permit. That is the person the police would hold accountable for any misuse of a firearm. That was your answer.
Yes.
Can you explain to me what that means?
I think, Your Worship, I think I said that the responsible person who's appointed for the company has administrative functions.
Yes.
And they're specified, particularly in the regulations. I've marked them here where the responsible person is required to complete administrative functions.
I think the administrative function is being dealt with, and it's not an issue in this matter.
But then
The register is all balanced,
Yes.
etc. It's not an issue. I'm speaking about the person the police would hold accountable.
So I've removed the responsible person from this debate because that responsible person has, for example, signed a firearm to a specific security officer, entered into the register, he has a permit. The issue of that permit means that that person who has the permit and the physical firearm is responsible for whatever happens with that firearm. If he loses that firearm, he gets charged. If he shoots someone in circumstances where it's not lawful, he gets charged, and so
If he
on.
leaves the firearm unattended,
He would be responsible for potentially negligently losing that firearm. Yes.
and then section 120 becomes applicable.
No, I think it would be section 120 sub 8. That would
Not
be applicable.
negligent in losing it.
It would be an offence probably in terms of one of the sub-provisions of section
We can
120.
settle on that. The only other concern that I would like you to clarify on, and this is the crux of the matter for me in this regard, is you yourself testified, you've been internationally recognized. I don't take that away from you, and I don't question your opinion in any manner. However, it is your own words when you were asked to read that section. It's extremely wide. The Act doesn't define. The Act doesn't define possession. The Act doesn't define. But you can't limit yourself to give your view based on the set of facts we are dealing with here today.
So, Your Worship, in 2022, the Constitutional Court gave a decision relating to certain provisions of the Firearms Control Act.
Mm-hmm.
And in that decision, they refer I'm guided by the legal practitioner. So in my opinion, the version postulated by the state in the formulation of the charges is neither reasonable nor businesslike in the circumstances of this case. That is my opinion.
In a nutshell, in your view, is section 120.10a then null and void?
No,
Serves no purpose.
no, Your Worship, we all need to take into account that we can't quote the section piecemeal. It says who is not allowed in terms of this act to possess that firearm or ammunition.
Yes.
So it's linked to a very specific requirement.
Yes, exactly. I agree. So, do you have an opinion on the set of facts that you've been, I'm sure, presented with during consultation by the defense? I've not heard you on that aspect.
Your Worship, I do not know the full facts of this matter. I have not seen the video for a number of years. That was not the purpose of me being called to give evidence.
None. So that's, I'm going to leave it at that. Thank you, Mr. Woods.
Can I be excused, please, Your Worship?
No, not yet. Sorry, there's a second phase to this. Advocate Matthews, questions based on the court's question?
Yes, thank you. I referred you to the further particulars in this matter, where the state has bound itself. These are the facts. The state has bound itself to the handing over of the firearm by accused number 2 to accused number 1. You understand that?
Yes.
All right. And I've referred you to the section 174 where worship said in her judgment that sure, there is no evidence that there is physical handing over of the firearm, but because the section says may give possession in any other manner. All right. Now, I fail to understand what other facts you've been given, the worship is asking you, to show that the firearm was handed over in any other manner. Have you been given any other facts?
No. No.
I think he was quite clear on that, Advocate Matthews, that he was not at the end of questions by court.
Anyway, the guest of the worship's question is a little bit different to mine with this case. The state is bound by what it says in the split of particulars that there was a physical handover of the firearm. All right.
Yes.
The fact is,
Yes.
there's no evidence as to that before this court. You understand?
I do.
Now we're going to this interpretation of this or in any other manner gives possession. And her worship in the judgment says because he was the owner of the company, all right, that means that in any other manner he gave him possession. You understand?
Can you
I do.
just refer to the page where I said he was the owner of the company? I just need to update myself as well.
Certainly.
Thank you.
Yeah, paragraph 20, page 25 of your ruling, line 19. The firearm in question being SAP 249/14 is indeed your firearm. Or the company's firearm.
The word being the owner of the firearm was not uttered by court.
The firearm in question being SAP 249/14 is indeed your firearm.
Did I use the word owner?
Or the company firearm.
Did I use the word owner?
No.
Thank you.
All right. That is the words used by the court. your firearm, the company's firearm. Now we established that it's not his firearm, all right?
Yes.
And the firearm belongs to a close corporation, as you understand.
Yes.
All right. Now the mere fact that the owner, in brackets, might be present on a scene where somebody uses a firearm belonging to the company, would that mean that in any other manner he supplied it?
No.
Thank you.
Thank you, Mr. Committee. Thank you,
The survivor, a few questions, if I may, just to clarify, arising from the worship's questions. They relate to the ammunition. And the worship asked you whether the ammunition for this blank firearm is available to buy in South Africa. Do you remember that?
Yes.
Now, what I want to put to you, sir, is that usually the blank
Correct.
you also said you don't need a license to purchase these firearms, you will need the competency to purchase a blank shooting firearm. I want to put you that the same would stand in relation to the ammunition. One doesn't need a license or competency to purchase the blank ammunition.
Well, correct. And in fact, technically, according to SABC ballistics, it's not ammunition.
Well, I have an issue there, and I want to show it to you because everybody's handed in or had the board to Exhibit L2, and there seems to be some uncertainty in that regard. If I refer you to
For some reason, I don't have the last page. Mine ends at paragraph 18.
Mine also ends at paragraph 18. Does it go beyond paragraph 18?
No, I'm only up to 18, so I have this from my own friends. But if you look at paragraph 17, it's encircled with somebody, the DPPs are also the view that even though the blank ammunition can technically be regarded as ammunition, in terms of the FCA, that the possession of such ammunition cannot be prosecuted based on the fact that the general public is informed that no license is necessary to possess such. So my question to you is, you said that, and I understood your definition of ammunition being ammunition that actually sends out a projectile. Here, this ammunition doesn't have a projectile, so but they say technically, even though it might fall within the definition, it's not an offence to possess it.
That's the Directorate of Public Prosecution's opinion. SABC ballistics have issued a directive saying it has to have a projectile in order for it to be ammunition, to fall within the definition of cartridge as set out in the Firearms Control Act with those four components: primer, propellant, case, bullet.
Now, my next question relates to the more recent debate. If one has regard to count 6, and I'll read it to you, that's the section 120 sub 1 sub A. You have to read it in its entirety to you, and I need to tell you up front, it only applies to accused 2, but it makes mention of accused 1, so that's why I want to make that clear. So it says here that count 6, accused 2, that the accused is guilty of the offence of contravening the provisions of section 120 sub 10 sub A, where the sections 1, 103, 121A, section 121, where the schedule 4 and section 151 of the Firearms Control Act 60 of 2000, and further read the section 157 of the Criminal Procedure Act 15 of 1977. Then they identified as providing a firearm or ammunition to any person not allowed possessing it. Now, I need to clarify this because they say further here, when they explain it in the body of the charge. And with upon or about the 28th of July 2018 at Sisa Dukashe Stadium in Mdantsane in the Eastern Division of the Eastern Cape, the accused will unlawfully supply or in any other manner give possession of a firearm and ammunition to it a .223 Malinka rifle and or a firearm, the make of the firearm unknown to the state, and a .223 Remington bullet to Julius Malema, being a person who is not allowed in terms of this act to possess that firearm and the ammunition. Now, I understood your evidence, and this is why I asked you this. to be a person who's not allowed to be, in terms of the act, in possession of the firearm and ammunition. And your reasoning is, I think, you must be a person who's been declared unfit to do so. Would that be accurate?
That's correct, yes.
Now the reverse, or not the reverse, the facts of the case has put you were that accused number 2 has never been declared unfit to possess any type of firearm. Could that then apply in your interpretation of section 120 to these facts in this matter?
If I understand your question correctly, and to put it in simple terms for me, are you suggesting it would be lawful for one accused to supply the other accused the firearm? Is that what your suggestion is?
Okay. I'm not suggesting. I'm using your evidence just to explain. As I understood,
I don't have the charge sheet in front of me.
I'll hand it to you, please. As I understand your evidence, and this is the point, is that possession is very, very wide, and you said in order to not be allowed to possess, because I can give my firearm to somebody else to shoot, but to make it an offence, that the person that I give it to would have to have been declared unfit to possess.
No, what I said was, in these circumstances as presented to me, because Mr. Snyman was present, then he, on the version of the state, and I want to emphasize on the version of the state, could lawfully hand that firearm to anyone in his vicinity where he could exercise control over that firearm.
I understand that. My point is the following, Mr. He could hand it over to anybody, and I put to accept a person who's been declared unfit to possess such a firearm, because that person by law is not allowed to possess
Yes.
So let's use the version of the state. Okay, as was put to you. On the state's version, accused number 2, it goes against the further particular. On the state's version, accused number 2 handed over a firearm to accused number 1. Accused number 1 is not declared unfit to possess a firearm. Is there anything improperly in doing so in his presence?
Under his control? No.
But I emphasize that's the state's version.
It's a hypothetical.
We've got different, or the same view of the video. It doesn't substantiate. If you saw a video, let me put it like, you saw a video of accused number 2 handing over a firearm to accused number 1 who had not been declared unfit to possess a firearm, would there be anything untoward or illegal in doing so?
No, as long as the person handing over the firearm was in his presence and exercised control.
That's how I understood you, and that's what I wanted to tell you. Thank you.
Thank you. Any questions based on the court's questions? Advocate Sisa?
Issues just one or two. You wanted to state earlier what is the 4 type of competencies you got for different type of firearms. You said there are 4 types.
Handgun,
Yes.
shotgun,
Yes.
manually operated rifle,
Yes.
semi-automatic rifle, pistol caliber carbine.
Is it correct that you have to go for training to get the competency in respect of each of that type of firearms, except for the revolver and the handgun? They go for the same competency, is that correct?
Well, the training doesn't distinguish between types of firearms at all. So it's a rifle, it's a handgun, it's a shotgun, and it's a semi-automatic rifle, pistol caliber carbine. So you don't talk about a revolver or a handgun.
Yes. But the fact of the matter is they are not the same. The handgun, the competencies for the handgun and the rifle are not the same.
No, the training is different, yes.
I didn't hear your answer?
The training would be different, yes.
That's correct. I did training for a handgun, a semi-automatic handgun. Can I now use that same competency certificate in respect of a rifle?
No. However, you do not need a competency certificate to use a firearm under the supervision and control of the license holder or someone authorized by the license holder.
And in the scenario that you just gave right now, the person is present knowingly I will be committing an offense with that particular firearm, still hands it to me, discharge the firearm in a built-up area. Is that allowed
Well, discharging a firearm in a built-up area
with people there?
is probably an offence. Yes, I would agree with you.
Thank you.
Thank you, Mr. Holmes. We have unmatched evidence, your excuse and wisdom.
Thank you, Your Worship.
Thank you, Your Worship. My next witness is a ballistic expert.
I just want to get my report with up-to-date cross-examiner. I like to know exactly on the page where we ended. It's
Sure.
easier than-
I'll wait. Another problem, Your Worship. We need to set up a TV screen. There's going to be a presentation as well as a demonstration. I need to ask permission to bring a blank gun into court. It is necessary for our evidence. Unfortunately, my ballistic expert suffered an injury last night. They did take him off to a clinic this morning. He suffered quite a bad cut to his head. Yeah. I don't know where he is or what the situation is with him. I'm told he's fine, but in any event, we're going to need some time just to set up everything for you.
Actually, Matthews, just before we set up and adjourn, what will the basis be for bringing in the blank gun? I think we're all in agreement that it resembles the real one as we've been referring to blank and real, that the untrained eye cannot distinguish, maybe even the trained eye. So is there any other reason that you want to present it?
There were tests done with it regarding the flash.
Do
But
I have
those
to
on
see
video,
it?
you don't physically have to see the flash.
So it's your choice.
As long as we're all in agreement that it looks exactly like the real one.
I will hear from the state and from.
I don't think my learned colleague will want it broadly.
If that is the case, just please accept the fact that I cannot grant permission for such. Security, our provincial security is present, Mr. Boppo, court manager, they are the people who will make a decision regarding such issues. I cannot. I think you can understand my position. I trust that what you will bring in will be a blank. But they need to authorize and prepare themselves for whatever is to come.
Too many cameras around to commit an offense.
I know, they're all over the CBD area and that doesn't stop anyone. Okay, so I see Mr. Sisa is present and Mr. Boko, I'm sure, is very close by. you will have a word with him, and is there space for this television that you want to see?
I see the head standing there.
Will I be able to see that?
We'll make sure that we can see it, because I don't care if anybody else sees it.
Sure you don't need to see.
No, I really do.
Okay, well, just discuss please with the relevant parties so that they may make an informed decision which will be in the best interest of everyone, and then just call me at any time when you're ready.
For the clerk.
Do you have any objection in taking the discharge oath?
No.
Do you then swear that the evidence you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Help me God.
Thank you.
Thank you, Your Worship. Mr. de Klerk, is it correct you have compiled a report pertaining to this matter?
That is correct.
If I may hand up the report, well, do you identify that this is your report?
That is correct.
I'll hand it to copy to everybody. Manelli will refer to it during the testimony to make it easier for the court.
So, then provisionally until the end,
Yeah.
it will be accepted as exhibit
M.
K.
M.
M. Exhibit M. M, I'm sorry. I said M. M.
M for Mary.
M. Thank you.
Thank you, Elder. Mr. de Klerk, is it correct that you have sat through this trial from day one until today?
That is correct.
You have listened to all the evidence, including the evidence of the state's ballistic experts.
That is correct.
You have also had access to all the ballistic charts handed in by the state in this matter.
That is correct.
You have compiled a report which you has been handed in as Exhibit M. Just to qualify yourself as a ballistic expert, will you place on record what your experience is, please?
100%. Look at paragraph 1. I was a member of the South African Police Services from 1984, and since 1989 I was a member of the ballistics section of the forensic laboratory, and in 1998 I left the ballistics unit of the forensic laboratory of the SAP. I left with a rank of captain. Paragraph 2, I received the following 3 years internal training that was given by the lab itself, and it's divided into paragraph 2 is the headings. I'm not going to go through all of it. Microscopic identification, internal ballistics, intermediate ballistics, external ballistics, terminal ballistics, and then additional training and certifications. That's paragraph 2.6. I visited the firearm ammunition manufacturers: Littleton Engineering, Trevelio, Sonken, Swartklip, Musgrave, New Generation Ammunition, Diplo Point, Nobletech, PMP, and Frontier Bullets. My experience in paragraph 3.
You listed out in paragraph 3 all your years of experience, is that correct?
That's correct, yes.
You have 35 years appropriate experience.
40 years. Basically 40 years of experience
Oh,
on
yeah,
investigations,
paragraph
experience of crime scenes, as per paragraph 3.1.
Okay. 3.2, you have 35 years experience application of forensics
That's
and
correct.
ballistics. The rest of paragraph 3, you set out your experience, is that correct?
That is correct.
And in paragraph 4, you set out diplomas, certificates, and medals of that.
That's correct. I would just like the court to note the one that was examined or made positive, but it's a similar one. It's just to show the court what. Now I'm going to explain all the parts of this firearm. First we'll have the flash hinder, that's right in the front. We'll have the barrel, and we'll see that the barrel is extended right up to the point. I'll show you now, front side. Your bayonet lugs, front swivel. You're dealing with a handguard, now your barrel is extended to the right. So it's from the front right to the back. And if I can just show the court. The firearm is split into two. You get an upper and a lower. If I talk about the upper, I'm talking about the top part of the firearm. If I talk about the lower, it will be the lower part. There's your detachable carry handle. Then we have a charging handle. We've got a position stock. This can move in and out. Cannot flip. It's only horizontal, if you can call it that. Then we've got your telescopic latch. Here we've got a buffer tube with a buffer and spring on the inside. It's the internal part. Then we have the rear swivel, pistol grip, trigger, safety lever. That's the magazine port where the magazine fits in. And then we have the carrier bolt release. In other words, if the bolt is at the rear, when there's no more ammunition in the magazine, that is to release the bolt that it can go forward again.
So let's just see, this firearm will fire. When you press the trigger, it will fire all the bullets until there's no bullets left in the magazine. At that stage, the part will stop.
At the back, that's correct.
Leaving
That is correct.
the mouth open.
Yes, it will leave the bolt carrier and will actually be in the rear position that you can see inside of the firearm. And then we've got the carrier bolt release, that's what I'm talking. Now I turn the firearm around so I can show the difference.
Can you just go back for a second? I'm just writing the last 2 minutes. Just a minute. Just thank you. I assume it's not part of the report.
In my report I didn't put this in as well. This is just an explanation for the court so the court can understand where.
1 second to record all the words, I'm nearly done.
That 100%. I can make a copy for the court. It shouldn't be a problem. When we turn the firearm around, so we're going to do the other side. What we've got here is the buffer tube. Now you'll see that the butt is extended, it's pulled out. It's just to show you the way it works.
This is a telescopic plate, that's what it's called.
That's correct,
In other
yes.
words, it stretches in and out, it doesn't fold
That's correct.
like an AK-47.
Then we've got the safety lever again. Got it on the left and right. Then we have a forward assist. That is, as soon as you charge the firearm, you put a cartridge in the chamber and it doesn't want to close, then you can use this as a forward assist to actually close the bolt. Then we are dealing with a deflector. We're dealing with an ejection port. A magazine release button. So if you want the magazine to fall out, this is the button that you will push. Then we're talking about the dust cover. And I made an enlargement of the dust cover to show the court what it looks like. And the court will note there's the deflector. That's your ejection port. And you can actually see the rotating bolt on the left-hand side. And this is just a small little flap that you can close it with to keep it clean. So I've taken closer photographs. This is just to show also a CQA, an Orinco CQA with a serial number. And what the court needs to notice, there's the rotating bolt. And then we've got the dust cover, closer. That is the extractor. The extractor used goes around the cartridge. Once it's fired, it actually hooks it and pulls it out. Then we're talking about the ejector. Then we've got the firing pin hole with a firing pin on the inside. You cannot see the firing pin. I've got a video a little bit later which will explain all of these parts, how they work together. Then we have the breech face. And that's on the bolt. Now the bolt is within the bolt carrier.
No, just even at this stage, just to clarify, you were showing all these separate parts. Is it correct that these parts all impart marks onto a cartridge?
That is correct. I'll deal with all of them separately, which I have included in my report as well.
Okay.
Okay, I've got the video. The video is going to play. I don't know what the volume is going to be, but
Pressing the magazine release frees the magazine from the lower receiver. Rounds are loaded and held under high force of the magazine spring. It's then inserted into the mag well and secured by the magazine catch. Pulling and releasing the charging handle chambers the first round. The charging handle forces the bolt carrier group to the rear. As it comes back, the action spring is repressed. As the carrier returns forward, the bolt strips the top cartridge from the magazine and guides it into the chamber. Housed within the bolt carrier is the bolt. The bolt contains several locking lugs that engage with the barrel extension lugs. As it makes contact with the barrel breech face, the bolt turns and locks into place. The locking function is due to the cam pin housed within the bolt. The pin runs along a track in the bolt carrier, allowing it to rotate. When the bolt is open, it's locked in the forward position and can only rotate once the cam pin has cleared the recess in the upper receiver. With the selector taken off the safe position, the AR-15 is ready to fire. A recess cut into the selector permits trigger movement. As the trigger is pulled, the hammer is released from the sear. The hammer spring drives the hammer forward to strike the firing pin, causing it to travel forward and impact the cartridge primer. Within the primer is the ignition compound and an anvil. As the firing pin strikes the primer, a spark is created, igniting the propellant inside the cartridge. The expanding gases propel the bullet down the barrel, where rifling grooves impart stabilizing spin on the bullet. The gases escape through a small port in the barrel, through the gas tube, and into the bolt carrier teeth, forcing it to the rear. The extractor grips the rim of the spent cartridge case and holds it against the bolt face until the ejector forces it through the ejection port, striking the deflector as it exits. As the bolt carrier comes back, it returns the hammer to its cocked position and stays held back by the disconnector. When the buffer reaches the back of the receiver extension, the action spring returns the bolt carrier forward. As it returns, the bolt strips a new cartridge from the magazine and directs it into the chamber. Simultaneously, the extractor clips into the rim of the new cartridge. Many ARs are equipped with an adjustable stock. The stock rides along the receiver extension, commonly referred to as the buffer tube. Pressing the release lever, moving it to the desired position, and releasing it will lock it in place. The ejection port cover can be closed when the rifle is not in use to protect the inner parts from outside elements. The cover opens automatically when the rifle is fired.
This video was downloaded from the internet. The video is much longer and explains everything inside the firearm. And I've just taken out the most important parts of the video.
You've identified numerous parts on the firearm. I see, sorry, carry on.
Okay. Now, if you look at the differences, you'll see that the cartridge case that was linked with the firearm, the serial, the one that's in front of the court, was a 223 Remington. The firearm is marked on the side as 5.56 millimeters. This is just to explain that there's tiny little differences between the two. If you go look at the specifications, you get two specifications to adhere to in South Africa. It's currently called the CIP specifications, I've written it down at the bottom, and the SAMI specifications. SAMI is normally used in your European countries where your CIP spec is more related to your USA. Now I've taken the liberty of a 223 on the left hand side and a 5.56 by 45. It's exactly the same caliber, especially if you look on the sides of the bullet at the top. But there are differences between them. If you go look at your 223, you'll find that there's tiny difference, and we're talking about 0.005 of an inch tolerances we're working in. It's very tiny. There is differences between the two, and you will find that most of these differences are on the neck or close to the neck. You will also find that your 5.56 are mainly manufactured for your security companies or law enforcement. It's loaded a little bit, the loads are more. In other words, because we're dealing with uninterrupted fire, they need a little bit stronger ammunition so that the powder or the loads will be different. 223 will be lighter. There's a two. Now if we're going to look at, we need to distinguish on tool mark comparison, the methodology. How are we using this? Now the methodology of tool mark comparison is the following, and this came from AFTI, it's their training manuals. All parts of a firearm are manufactured by the use of different tools. So if we take the firearm, we take an example, the extractor or the ejector, there's different tools manufacturing that tool or the extractor. Once I use the firearm, that extractor becomes a tool on the cartridge. That's how you've got to relate to. Each tool used will have its own distinct markings, striations, damages, etc., which are expected to be transferred. So all of these parts will transfer. In most of the cases, depending on the ammunition that you use, will be transferred to the cartridge case for the fire bullet. These marks from the tool will transfer to a second object into class characteristics, subclass characteristics, and individual characteristics. And I'll explain all of these, exactly what it means. Now the tool that's used, the first tool, changes over time, the imperfections in wear and tear while they're using the tool. Now the lifespan of the tool will determine the uniqueness. So the older the tool becomes, the more unique it will get. When the tool is used, one needs to keep in mind today's technology and advances in tool consistency and composition of each tool. If we look at Norinco, which is a Chinese-based company, they will definitely use the broach or the mandrel that they use, and I'll explain a little bit later what the mandrel is. If they use that tool, it's not going to just produce one firearm or 10 firearms. They could probably make thousands of firearms with that one tool. Then we need to identify the tool marks You're dealing with tool mark identification. Can you see it? There. Tool mark identification is a discipline of forensic science which has its primary concern to determine if a tool was produced by a particular tool, which can be divided into two main groups. The first one is the impressed mark. In other words, if I take a hammer and I hit it on the table, that will be an impressed mark. The mark produced when a tool is placed against an object and enough pressure is applied so that the tool leaves an impression in the object. The class characteristics, example, shape, size, orientation, can suggest the type of tool used to produce the mark. The individual characteristic can be used to identify the tool with the mark. Then we're talking about striated or striations. This is where it's basically scraping marks. Marks produced when a tool is placed against another one and the pressure is applied and the tool moves across the object, producing a striated mark. Friction mark, abrasion marks, and scratch marks are terms commonly used when referring to striation marks. These marks can be either class or individual characteristics. Now we're going to work with definitions, and I'm going to define class characteristics. This is according to AFTI. Class characteristic is measurable features of a specimen which indicate a restricted group source. They result from design factors and therefore determined prior to the manufacture. For example, the groove diameter, the size and the shape of the firing pin. So these are class characteristics that are already determined. If we look at the bolt, the class characteristics on that bolt example will be that if the extractor is at 9 o'clock, you will find the ejector at 3 o'clock. That's class characteristics. Now we're dealing with subclass characteristics. Now subclass is discernible surface features of an object which are more restrictive than class characteristics, in that they are produced incidentally to manufacture. It's toevallig, the word toevallig. Are significant in that they relate to a smaller group source, a subset of the class to which they belong, and can arise from a source which changes over time. That's subclass characteristics. Then we're dealing with individual characteristics. Individual characteristics is marks produced by a random imperfection or irregularity of the tool surfaces. These random imperfections or irregularities are produced incidental to manufacture and can caused by use, corrosion, damage. They are unique to that tool and distinguish it from any other tool.
So in other words, if a firearm has got these individual characteristics, it's implanted onto a cartridge case, one can then say that, subject to what is to follow, that firearm, these marks are unique to that firearm.
That's correct, or that tool.
That tool.
The firearm is made up of a lot of different tools. So you can identify one tool. Now what do the expert or the examiner use? They use a comparison microscope. And this is just an example of one. And I'm going to go through it. You've got a camera at the top, you've got your ocular lenses where you're looking. Then you've got your comparison bridge, which divides the comparison microscope into two. And you will have on the left, you have an objective state, and I've actually brought an example for the court, that the court can see what it looks like. This is now this part. If I look on the stat part, and this is what it looks like. So in other words, when you use it, you'll have your cartridge there, and it can turn up and down. It can swivel, so you can put, if you place the cartridge here, you can actually view the cartridge anywhere without taking it off. You don't need to take it off. And then also what needs to be noted is that it's marked, it's got measurements on it. So in other words, once you set up your cartridge, you will have the orientation of it. Right, so you'll have example, you'll have your extractor or ejector at 1 o'clock, 2 o'clock, what, by the test and your exhibit will be the same. So if you find a unique mark somewhere else, you know if you look at that at 30 degrees, you should be able to see the same mark.
This is stop there because it needs clarification. You are looking through the top.
Yeah, yeah.
On the left-hand side is what?
Is your, normally your exhibit.
Is the exhibit picked up, say, at the stadium.
That's correct.
On the right-hand side would be a test cartridge case that you fired from the same firearm you suspect to have fired the one on the left.
That is
Correct.
Yes.
Now looking through the top, you can see both of them.
Yeah, I've got an example here on the right. You basically see a circle, you'll see a dividing line, and you'll see the exhibit on the right and the test on the right. If you look at the court charts, I think it's exhibit A, you can see the thin dividing line in the center. This is how it works. What the court needs to understand is that there's light sources. Each one of them got its own light. So you can change the light up and down, left and right. So the shadows and valleys that you can see it through the microscope. Now if you look at there's 3 enlargements or 3 different microscopes. So in effect we've got 6 microscopes built into one.
Okay.
Then I've done comparison marks. These are all marks that can be found on a cartridge case. It's not in all the cases. It can be that some of the marks are missing. It's possible. Now I'm going to deal with all of them. We're first dealing with a firing pin mark. That's in the center. If you look at the cartridge there on the left-hand side, you can actually see the little divot. And that is produced by the firing pin that's inside there. Then we're dealing with your breech face. Breech face is marks are normally situated here. There you can also see some breech face marks.
You speak at the talking your voice.
Sorry?
Talk louder, you're dropping your voice.
Okay, sorry. Ejector or extractor marks. It's on the side as it goes around the cartridge case at the back. Then we have ejector. Now this is just a sample or an example of where marks that can be found on a cartridge case. I'm not saying that this is what they should have found on the cartridge. It can be different. In other words, the extractor can be at 12 o'clock and the ejector could be at 6 o'clock. But this is the marks that you will find. Then we're dealing with chamber marks. I divide it up into 2. You get neck chamber marks and you get chamber marks on the side. Now here at the bottom, I've got a barrel that has been cut open. And on the right, you can actually see the chamber. And the chamber starts right from the front, right to the back. So any mark found in that area on the side of the cartridge can be defined as chamber marks. But because it's neck chamber marks, it just gives us a better indication where the mark was found. It's a neck chamber marks. And we're dealing with magazine lip marks. As the firearm picks up the cartridge, you can find magazine lip marks. And we need ejection port marks or deflector marks. As the cartridge is being thrown out of the firearm, it hits to the side. Then we're dealing with feeding ramp marks. As it's fed into the chamber or the barrel of the firearm, normally you can find marks there as well. We're looking at neck marks. And then we're dealing with leg groove marks.
Again, these are all marks that one could find on a cartridge case which has been fired with a specific fire.
That is correct. Normally you will find a combination. Sometimes, depending on the pressure on the inside of the cartridge, some of these marks will not transfer. Sometimes it happens. Now we're going to I'm going to do a range of conclusion results and findings currently used by the ballistics unit. Positive, undetermined, and negative. Now this is significant agreement of marks. That's why they make it positive. Undetermined is basically it's not sufficient marks. And no agreement is negative. Now, AFTI range of conclusions is the following. Based on the AFTI theory of identification, same source identification, there are 4 categories of examining the outcome, range, and conclusion possible when comparing 2 marks. Typically used by firearm examiner in the microscopic comparison of fire cartridge cases and shotgun shaft cases. These categories are divided up into the following. I will explain each one of them. Identification, same as positive. Inconclusive, same as undetermined. And elimination is negative. You eliminated it. And then there's a 4th one, which they use is unsuitable for comparison. The lab will normally use undetermined and then explain that it's damaged to an extent that they can't find any marks. Now we're dealing with identification of posit. Now, the AFTI glossary defines identification as follows. It's agreement of combination of individual characteristics and all discernible class characteristics where the extent of agreement exceeds that which can occur in the comparison of 2 marks made by different tools and is consistent with the agreement demonstrated by 2 marks known to have been produced by the same tool. The statement reflects the concept of significant agreement and best known non-matches. All identifications are based on pattern matching. It is possible to go beyond the qualitative match to the quantifiable consecutive matching striation approach by further support of an identification. Then we're dealing with inconclusive. An inconclusive result is noted as the outcome of a comparison in which there is some agreement of individual characteristics and all discernible class characteristics, but insufficient for identification. Agreement of discernible class characteristics without agreement or disagreement of individual characteristics due to the absence of insufficient or lack of reproducibility. Agreement of a discernible class characteristic and disagreement of individual characteristics, but insufficient for elimination. Going over to elimination, it's a little bit longer. It's the final glossary. Elimination is the significant disagreement in discernible class characteristics and or individual characteristics. For the purpose of a fire cartridge, shotgun case, comparison, and elimination is most often based on observed difference in any class characteristics. So the class characteristics will be immediately different, so you will not do the comparison for individual characteristics because you know that it's different. However, an elimination based on individual characteristics is more complex. Conceptually, an elimination based on individual characteristics means that the firearm can be shown to have never been subjected to significant use or abuse over a period of time. The quantitative aspects of the striations produced on a fire cartridge and shotgun case should remain the same. The difference in these qualities indicates elimination. Elimination based on individual characteristics requires a detailed knowledge of the history and the treatment of the firearm, as well as the documentation to support the theory of the history. It is the responsibility of the examiner to provide this historical document. The type of elimination should be approached with caution. Many experienced examiners have never made such an elimination, and the protocols of many of the laboratories do not allow this. Elimination are sensitive and important as identification. When eliminations based on microscopic marks alone are permitted by laboratory protocols, this process should be adhered to strictly to criteria for an elimination. set out in those protocols. When a firearm is included in the evidence and an illumination is based solely on the individual characteristics, the examiners may add consistent phraseology to the report indicating that the conclusion was based on the condition of the firearm as received or the firearm in the current state. Now we're dealing with unsuitable, the last one. AFTI glossary designs that they're unsuitable for comparison. This outcome is approached where a fired cartridge or bullet is mutilated to such an extent that the marks are not visible. I've taken Exhibit 8. There were 7 court charts handed in. And I'm going to deal with each one of them, of all the court charts.
We can start off with the one to change. This is the important part of the
Yeah.
the crux of the matter.
And before we start, since we didn't actually attend the anything else, and then we will proceed.
All right.
case, the state's ballistic expert ended up, well, in essence, 7 photographs, charts. In fact, he didn't explain what he found in these charts, simply to say that his conclusion was that the firearm fired because of getting the person. Is that correct?
That is correct.
Now, you have the similar charts. I want you to go through them and give us your expert opinion as to whether this conclusion is correct.
First thing that you will notice on the court charts, I marked them 1 to 7, and I've examined all of them. So I'll go through the first 2 court charts, court chart 1 and 2. qualification and was not considered or used.
So is that the blue arrows indicate all different?
There's also differences, yes, which is not on the exhibit case. I just want to show the court there's a thin black line in the center. That's the center line of the microscope. When you look through, on the left-hand side is your exhibit, the one that was picked up, and on the right is the test that the colonel fired in this firearm. By comparing the marks found, it is very important that the marks must be considered as possible subclass characteristics and should first be eliminated before going over to the individual characteristics. tool. Same source identification in one area using one tool would be a fatal flaw in the examination process as well as the conclusion. Now, since I've been in the ballistics unit, it was always said you need to follow up. Always. And the rule of thumb,
Just repeat, to what follow up?
follow up. In other words, if you find striations that's similar,
The first part of your sentence?
since I've been at the ballistics unit from 1989, it has been drilled in you have to have a follow-up. And the Lieutenant Colonel actually testified that he followed up. But he used the same tool, same area. And that's where the problem is. He had to find something else. Now, on the comparison, this is all the marks that you can find on a cartridge case. He testified that the firing pin is negative. Of the particular cartridge, he said it was negative. The extractor was negative, the ejector was negative, and the breech face mark was negative. That cartridge that he found was negative to the firearm. I divided, like I testified earlier, the chamber and neck mark. I divided them into two. He didn't use other chamber marks. He used neck marks, or neck chamber marks, which he made positive. Ejection port, he didn't use that. Magazine lips, he couldn't find it, didn't use it. The lead and groove, he didn't use it. So this is just an illustration to show the court. Out of all the marks that he could have found, he only used the neck chamber marks. Now, according to me, according to standards, second tool. You need to find a second tool to make it. Standard based on evidence and testimony. Same source identification, a positive identification. If you look at the to those and not to by just using neck marks. According to the evidence, all firearms were collected for examination and comparison. And Lieutenant Malema could not match any of these marks to any other firearm internal parts. None, with the exhibit fired cartridge case. The assumption is now made that Lieutenant Colonel Malema could not find any other individual characteristics of possible matches or non-matches, irrespective of how small or irrelevant they might have been. So if you can look at all the marks that was available to him, he made it negative. So if you go to explanation or elimination, the definition of it, he created and said it's negative. And out of those, all the other firearms, he couldn't find one striation, not one little line that matches up at all with any of the other firearms, which is the same. The class characteristics will be the same. It's the same firearm. The models are the same. The serial numbers follow each other. Last time we were on court, we asked permission to take photographs of the exhibit cartridge case. And I've taken this photograph myself, these photographs that I'll show now. And I used the Samsung S10 phone taking a photograph. And this is on the side of the cartridge case. This is the exhibit that was picked up. Here's a mark. This was most likely produced when the cartridge was ejected. Let me go further. Look here, this is where you can actually see the mark, and here you can see other marks available. Here you can see the extract or ejected marks is here available. Make that negative. And looking further there, you can see that mark again, a little bit clearer. Still marks here also. Here as well. This is the breech face at the back. All I need to show the court, this is where the breech face markings tend to sometimes you'll find it on, but this is very hard. It's harder than your primer. Primer is soft. Now, FT's theory of identification, and the court don't have to write down, I'll give the court a copy of what I've got here. Pleasure. All I want to basically highlight is the theory of, I'm going down, the theory of identification as it pertains to tool mark enables opinions of common origin to be made when a unique surface contour of two tool marks are in sufficient agreement. This document comes from the FT training manual from 2024. The sufficient agreement is related to significant duplication of random tool marks as evidenced by the corresponding of a pattern of combination of patterns of surface contours. Significance is determined by the comprehensive examination of two or more set surface contour patterns comprised of individual peak ridges furrows. It goes further and then explains you need a second set of markings. You use the same tool or the markings that the tool that produced the markings that he photographed was one tool of the firearm. And out of the video,
very close on. Do you understand correctly what you were saying? You might have made a positive match, correct?
that is correct.
Because
You didn't have the necessary follow-up.
he found only neck marks on two different places instead of neck marks, plus maybe the extractor, the ejector or something else.
That is correct.
And that is international standard.
That is correct.
And in any event, you just go back. Your observation of the charts indicate that you shouldn't have even made a positive match on the neck.
There's a lot of differences which I didn't examine the actual cartridge, but there's definitely differences that's visible that would warrant not a positive identification. I would rather have made it undetermined because there's so many differences that I can also see. And that's where the subclass characteristics, you first need to go look at the subclass characteristics of which of those marks are unique to that particular firearm. And based on that, only then can you make an identification. But now it's same source identification, so you have one tool. To follow up and actually get a positive identification, you need a follow-up somewhere else, different area. You cannot use the same tool.
All right. Now, this you're putting up here to be a person standing with the fire.
With a firearm, that's correct.
This is the flash.
That's right, that's my instructions.
All right.
So what
You conducted flash tests on a blank gun, is that correct?
That's correct, I did.
You made a video of these tests.
That is correct, I'll show the video a little
You
later.
played fast.
Okay, can I just, correct?
Yes, correct.
Okay. Thank you.
Sound is very funny.
Yeah, sounds very good.
Could I put up the sound, please?
That's right. Try this. Louder so it can go, sorry.
Right, take us through what you're doing then.
I'm explaining the cartridge. It's a 9 by 22 millimeter. It's a blank cartridge. You'll see now I'm going to the back and then I'm going to shoot. I think it's 5 shots. And it's in the dark. It's also a backlight, unfortunately, the camera that we use. But you will see the blank. I will make this available to the court as well.
Play it again.
Can you just play the firing?
Sound for
As I pause it.
one flash.
Let me see if I can
Okay.
find it.
Lost this jinx. Alright, is that it?
Okay.
Tell me. This is probably a late question. You're comparing fingerprints. But I have 7 points of similarity. Correct?
That's correct.
Before an expert can say it's the same.
That's correct. And normally what will happen is they will mark out 12 points and not just 7.
What happens in ballistics?
Ballistics is no limit. There's no limit. There's no, to say on a scale of probability, you've got to have 10 lines or 10 striations that you say there's no limit. If the mark is unique enough, it can be used.
But you require 2 separate places for 2 separate tools
That's
before you
correct.
can make a positive find.
That is correct.
Is that what you say?
Statutes.
And this is a standard that you say is universal.
That's correct.
Now, in appearance, we have the blank gun. We all agree in appearance that it's very similar to the original. In fact, it's the same.
That is correct.
It is available if my friend for the state was to put it out and evidence.
I can pull it out if you want. I've got photographs of examples as well.
Will you show us the photograph of the example?
It sounds
I
like
didn't-
he was going to pull out
My
a
lady,
fire.
my lady is a bit nervous of the gun.
Not that much.
There we are. All right.
All of these, and you can have a look, appears to be the real thing. But only 2 of them are real. The rest are all blank or airsoft cut. So this one,
Let me guess which one you
this one is real. The second one from the
Wait,
left,
wait.
and this one is real.
Yes.
This is only real. What I would like the court to notice is that the carrier handle, the back of the stock, the A-frame at the front. And I've taken a photo, enlarged this photograph just to show the serial number and the caliber. In South Africa, when they manufacture these are chambered for 5.56, but because of the law and the ammunition, they put in 223 as well, because you can fire both of his calibers in this particular fire.
Tell me, we saw when the colonel was firing tests with the real gun, it continued to jam.
That is correct.
Why was that?
Well, guess as good as mine, but probably either the ammunition was wrong, what he used, or the firearm was dirty.
223 used in a 5.56,
Yes,
and the other way around, would that
same thing.
cause a problem?
Yes, especially 5.56 fired into 223 caliber firearms. Yes, this is manufactured for 5.56, so I suspect that firearm was either dirty or the ammunition was not 100% correct.
I'm not clear on his explanation now, compared to saying you'll see printed on the enlarged photo 323 and then 5.56. Now, the explanation based on what he said there, I'm not following. For him.
No, it goes about the test done by the colonel.
I know now he's saying that about the test of the colonel, but his evidence prior when he testified about the
No, he
enlarged.
was just saying that he's taken a class up to show that it's a 5.56.
South African made ones is showing, and that you can use the 223 and 5.56.
That is correct.
That's simple.
No, I can't bring that to his explanation now. Maybe I'm
The ammunition can be fired in both guns, it's just that
Yes.
it does cause a problem in the one type of gun. It can jam, as we've seen when nothing turns on. Nothing turns on. I didn't imagine raised it, nothing turns on. Alright. The ejection of the cartridge case, we also did tests on that, is that correct?
That is correct.
And if you can put those photos up of the DRC stadium. Yeah, this is it. We apologize for the left-hand photograph here, that we struggled to reduce it. This is the witness who was pointing out where she found the cartridge case.
That is correct. As you can see there where the X is marked.
And we've established that where she was standing will be in fact a tent
That is correct.
for food.
And that is the end of the stage. If you look where she was in the evidence, this was given to her in the photograph, and she marked out the X and said this is where she found it. Compare that to photograph 8.
I think it's common cause, and not in this obviously, that the firearm ejects to the right, and I can't recall the exact meterage. I don't think that was a challenge.
So it's less than 2 meters to the right. To the right.
So, if that cartridge case was there, had been ejected from the firearm would have to be within a 2 meter radius of that.
That is correct. I would have expected if somebody was standing there firing, that you will find the cartridge case. Probably most likely be either to the left, or if you look at the,
Of course, the other possibility, more than likely probable, that cartridge case was not fired there, somehow landed up.
that's also true.
That's not if I've forgotten anything.
Not that I can think of.
Thank you. Let's just go back now to your report. Sorry. Paragraph 6 and 7. Relate to a test that you were requested to do on
That is correct.
the same firearm SP A237, 245, 246, and 248.
That's correct.
The one in question, the
239.
is which one? one we've got here in Corpus identified, what is the number again? Just
I think it's 239
239.
slash 14.
Isn't it
248. 248. There's a typing error in here.
The 245, 246, and 248.
Yeah.
Was the other one on 247?
Good. Can you?
Alright. You tested these firearms, is that correct?
That is correct.
Nothing turns on it in this case. And you later explain the method used for testing.
That's correct.
Explain the microscopic examination in paragraph 12. And there you point out
Now we'll
why
mark it.
don't you ballistic people ever put numbers on the paper?
No, we don't.
Anyway, I'll show you this one with the back of the PMP 223 Remington. You point out where marks are found on the cartridge cases.
That is correct.
And then you come to your conclusion that you've already testified about. Is that correct?
That is correct.
Thank you. You confirm that.
That is correct.
You confirm that the presentation you've given for court is part of your evidence, and you can put it onto a USB for the court.
That is correct.
You watch and whenever they want.
That's correct.
Mr. Dukashe, the blank firearm is available in court. You've examined it.
I've examined a blank. I don't know if I examined this one, but yes.
And the one that's here fires in the manner that you showed in the video.
That is the serial number. I've actually written down what it was.
And if you have regard to what you saw on video and the test that you've done, would you agree that the blank firearm looks exactly the same as the actual firearm?
That is correct.
And that it would be very difficult to discern the difference from a distance between the real and the blank firearm.
That is correct.
Now, when you did your testing on the actual Marinkov rifle that was there, what was the maximum range that it could eject once it ejected the...
Still stayed within 2 meters from where you were firing.
So it
To
was-
the right, about let's say half a meter to a meter, and 2 meters away.
So it's to the right, backwards, or to the rear, with a maximum of 2 meters.
That is correct.
Now you're explaining the difference between 223 and 556. I put you that there's a very, very small difference that one can't even see with the eye. If one looked at the rounds unmarked, would be good.
That is correct.
For an expert like you, the difference would be the primer. One is a Bergen primer, one is a boxer primer, but you don't see that from outside of the cartridge.
Now that's normally your 556, your military ammunition will be a boxer, or burden, which has 2 little holes, or flash holes on the inside of the cartridge. And your reloadable, your 223 Remington will have 1 flash hole or 1 hole at the back.
But to a person looking at the rounds, it would be exactly the same.
Look the same. If you don't read the head stamp and it says 223 Remington, on your 556 you will have a date and a number. That's basically all. It's going to have 2 sets of numbering.
And the actual size is minimally different that you won't see with the natural rifle, so much so that you can fire them, in most instances, interchangeably between the different firearms.
You can't fire them in different fire or different caliber fire. 223 you can fire in 5.56, but the other way around you will tend to find that if you shoot 5.56 into a 223 chamber, it will get stuck most of the time. It doesn't happen always, but it can happen. We found that there is problems, especially if you differentiate between the calibers.
You've been in court, you've watched the evidence, you've participated since the beginning, and I just want to put the following objective factors to you. This alleged incident took place at a packed stadium. Would you agree with that?
That's correct, yes.
There were many eyewitnesses present for this celebration. You were aware of it.
That's correct.
Not one of those eyewitnesses have complained of any firearm being discharged.
That's correct.
Only over and above that, there's been no complaint of anybody feeling that they're in danger of having been shot on account of a firearm being discharged in a public area. Would you confirm it?
That's correct.
You've seen the video, you've watched the shooting. You don't see anybody running for cover. Do you agree with me?
That is correct.
What?
That is correct.
We've been here for years now. We haven't heard of one eyewitness that watched the actual shooting and expressed any fear. In the gear house, people that were there never expressed any fear of having been struck.
That's correct. Confirm.
Over and above that, and this is where I'm going to come to your field of expertise, we've heard that there were 5 SAPS VIP Protection Service members on the stage at the stadium at the time. You've spoken in your report of your extensive experience in the SAPS. What were they required to do if they were there and actual rounds had been shot at the stadium?
Well, they were in charge, according to my knowledge, is they're in charge of a VIP protection unit and was allocated to Mr. Malema to look after accused number 1. To look after accused number 1. And their objective is to safeguard him, but if there was any firearms fired, I would have expected the police to actually intervene.
By intervene, you said put an end to it and take the firearm away and possibly arrest people.
That is correct.
Now, we've heard from the witnesses that those police officers made statements, but there's no mention of anybody having intervened or done anything to resist any firing of the firearm in the public area. Would you confirm?
I've had access to the statements, yes, I agree.
Now, drawing on your last slide that you showed us, those 2 slides together, at the point where the cartridge was found, and which as was put to you by my little friend, was under a food tent. And you're aware, and you watched the trial, that there's no damage to any of those canvases or tents. Is that correct?
That's correct.
Is there any possible explanation for how that cartridge would have got there at that distance and with all those structures in place?
There's only 2 possibilities that I foresee. First of all, that it was moved and dropped inside the tent. And the second option is when the stage was broken up, it could have been kicked up to the point where they found it. That's also a possibility.
You speak of 2 possibilities. I want to put to you, so if it had been there before the celebration, it would also be a possibility.
That's also a possibility, yes.
Because the place there after the celebration is another possibility.
It can be planted as well, yes, I agree.
Put somewhat differently, it's not possible for you to say when that cartridge was actually placed there.
No, you cannot determine that.
But one thing's quite clear, and that was on the put to you, so is a person standing on the stage where you saw accused number 1, if such a person fired a real bullet with a cartridge that was then injected, it is not possible for it to have traveled to that distance purely from being injected.
No, it's not possible.
You're also aware that there were no touch DNA traces or fingerprints that link any of the accused to any of these firearms or ammunition. Is that correct?
I don't know, but I can't dispute that.
You also have heard that there's never been any powder residue tests conducted on any of the accused to place them on the scene or in the vicinity of a firearm being fired.
That's correct.
You were also present when Sergeant Beck explained they had reconstructed the scene to ascertain where the spent cartridge had been picked up. You were present in 14.
That's correct, yes.
Was it in any way possible for that cartridge to have got to his reconstruction from being injected by a rifle at the time?
No.
Because you might now be permitted to turn to both my client and my issue just to see if they're ready. Thank you so much for the question. Thank you.
At this stage, that's a late hour. I also would like to consult with Mr. Guadaleka as well, who is present relating to the evidence, if we can roll the matter until tomorrow.
I've got no objection. Okay.
The rest of also, it's only fair because you need to anticipate this for another.
Would your worship like us to download this for you and give it or after the
Even if it's after, I'm more interested in the content of these evidence than the actual visual. That's when,
No, I'm just asking.
yeah, I would appreciate any. Both of them would be wonderful.
Thank you.
I wanted to be excused quickly before we should postpone the case. Will be 1 second.
Just pause the record, please. So it shows us the efficacy and
Yes, it's just, yes, thank you, Shirley.
Please, Mr. Deputy, you can stand down because when we come back, we will just do the postponement. I know that the excuse is not clear immediately, but with the college yourself and also the elders, Mr. I wanted to say to you, I just want to discuss counseling with you for tomorrow, because obviously this matter I was running two courts to. So I want to know time frames for tomorrow so that we can be on the same